April 2024, so you had your evidence on in October 2023. In April 2024, a Scott schedule finally went on, and that identified 4,000 alleged defects. The plaintiff at that point remained non-committal as to whether or not any further evidence was going to be served. Then in October 2024, the owners' corporation further engaged to the experts to undertake a re-inspection of the property, but this time to inspect 100% of the units. So again, for those involved, you would know that to arrange inspections of units, particularly that number, is quite an effort, and it was going to take quite some time. So they wanted to inspect all of the units plus all of the common property areas. And then in November 2024, so this is 12 months after they had put on their evidence in the October-November period in 2023, they finally made an application to serve further evidence, and they asked for 10 months to do it. So as you can imagine, the court was unimpressed. Justice Stevenson had a little bit to say about it. So in his judgment, so they put on the application, the defendants said, well, hang on a minute, no, we don't agree, because obviously they already had a Scott schedule for 4,000 defects. They didn't then want this Scott schedule to blow out quite substantially, so the defendants opposed the application to put on additional evidence. And this judgment relates to the determination of that application. So Justice Stevenson said, at the time the Owners Corporation's expert evidence was served over a year ago, those advising the OC thought it would be sufficient to serve export reports based on an inspection of only a proportion of the units in the building. That was a forensic choice that was then made by the OC as advised by their legal representatives. He then went on to observe that there was a change of heart by those advising the OC. A decision was then made that the question of the defects in the uninspected units cannot be left as a matter of inference but must be proven. So some of you may know there's a chain of authority in the courts which say if defects are systemic, you can't just inspect a few of them, or 50% or even a higher percentage, and say this is a systemic defect. Experts actually need to go in, observe every single unit, and hand on heart be able to say there is a defect in that unit. It is not enough to say I've inspected 50% of the units, and of that 50%, 100% have a problem, therefore all of the defects have a problem. Many, many years ago that may have been accepted. It's not the case now, and only those defects in units which have been inspected can be proven and claimed. Quite scathingly, he said, this case represents an example of how proceedings in the list should not be conducted. Now, judges don't often come out and say things like this, but when something has been done wrong or it's a waste of the court's time, we generally sit up and take notice. So they really copped a scathing in the judgment of the matter. He referred to Section 59 of the Civil Procedure Act. So some of you may have heard of Section 56 of the Act, which generally says that proceedings must be run in a way that is just, quick and cheap. Often we have a joke and say they're trying to run it just quick and cheap without the comma. Often that's how ANCAT seems to do things. A little less known is Section 59. And this says that in any proceedings, the practice and procedure of the court should be implemented with the object of eliminating any lapse in time between the commencement of the proceedings and their final determination, beyond that reasonably required for interlocutory activities necessary. So the interlocutory activities are these timetabling issues, the filing of evidence and so forth. So it has been it's uncommon, but it certainly has happened, where an expert has had a personal cost order awarded against them. So a well-known and well-used expert who is still practicing today had a cost order made against him some years ago. And he was, they were having to put on affidavits, and every time the lawyer would get a new timetable and the timetable would be breached and more affidavits are going on to explain the delay. And in the end, the expert was ordered to put on the affidavit and was hauled before the court and was given a personal cost order. So when preparing your reports, when a lawyer says to you, when can you get your expert report on, try to make sure that that date is fairly spot on, because otherwise questions are going to be asked, particularly if it's happened a few times. Don't take on too much than you can handle. A lot of the time, experts, lawyers, barristers, we seem to say yes to everything, and the risk of doing that is then not being able to keep up with timetables. And there's nothing more frustrating than a lawyer on a Friday afternoon saying, hey, where's your report? So in the end, the court really had to go at the plaintiffs for really mismanaging the timetable and what they had done and their strategy and the change of mind. But he did recognise the seriousness of the potential systemic defects, which had not yet been reported on. If proven, it was said that the cost could amount to a remediation of up to $8 million. So he noted that denying the request for the extension of time would deny them that opportunity to properly present its case, and that would not be just. So he did grant leave for the further expert evidence, but on a limited basis. So it was a much shorter time frame than the 10 months that had been requested, and they were ordered to pay the defendant's costs by reason of the making of the orders. So the takeaway for experts, success in a building defect matter, in all matters, but often in these matters in particular, it will turn on the expert reports. So it's really important to get those reports in, preferably on time, and right the first time around. It's really important that a clear litigation strategy is set. So often that is set by the lawyers, but don't be afraid to say your piece. So if you are engaged to inspect 50% of the units, for example, don't be afraid to say, I can't report on systemic defects. If you want me to report on all of the units, I need to inspect all of them, and you need to engage me to inspect all of them. So I recently had a case that I'm running at the moment in the Supreme Court. I think it's 160 units. My instructions from the owners were to obtain engagement letters and quotes for 25, 50, and 100%. And my experts gave me that, and then it was up to me to go to the AGM and say, I've got you these quotes, however, I recommend that it's 100%. Ultimately, that's what they did. So it's a matter of the experts and the lawyers working together to then corral the client into the space that they need to be in. So if you opine that a defect is systemic, every single instance of that defect needs to be investigated and reported on. You cannot report on something if you haven't inspected it. And just remember that leave to file additional evidence or late evidence won't always be granted. So don't assume that you can't get your report in on time. If you can't do that, don't assume that you're automatically going to be given an extension. You may not be. And in the extreme case, after a few non-compliances, you may be hauled before the court. And as I said, in those very extreme circumstances, you might be getting a personal cost order against you. Any questions?
How many cases have you seen where a cost order has been brought against?
Just the one. So I've been practicing for over 20 years. It's just the one. It was an extreme case. Because that particular expert had taken on too much work and had just kept breaching the timetable. But they were then having to put on an affidavit and were actually called in to give evidence. And often a lawyer will put on an affidavit because we've run late for various reasons. I'm putting on one today because I've got a guillotine order and my expert got COVID. So I'm having to do that. Got a letter from the expert. I don't expect that I will be hauled before the court, but when it happens on a number of occasions, the court will generally get fed up and haul someone in.
And what kind of costs are they?
Look, it will depend on the costs that have been thrown away. So, for example, a court might order that the costs of today's appearance be thrown away, and often the appearances, particularly at the moment, they're done online or they're done electronically, so it's less. But if the parties can't agree on the timetable, or if it's a big dispute like this one, everyone is rocking up, often with barristers. And if you need to pay the costs of that appearance, then it's going to be thousands of dollars, because for an expert, for example, it will often be the costs of the defendant, so their legal team, including their barrister, the costs of the plaintiff, their legal team and their barrister, and often that is going to run into the, maybe $10,000 range if both parties have barristers. So I don't recommend it, but also reputationally is not a good look for you either. So.
Can it be, if he doesn't serve the report on, you don't serve the report on time, can he be, can they claim against you for the loss of that claim for defects?
Generally,
Just the court costs?
it's generally just the court costs, because,
The defects themselves?
look, it would depend on whether they are completely locked out for making that claim. I've certainly never known the claim to extend beyond legal costs, like a damages claim, because you don't know what may have happened, even if they got the report on, whether they would have succeeded in that claim, because a lot needs to happen before they are successful in that claim. So generally speaking, it will just be a legal cost order. And as I said, very extreme case, but my suggestion is to set a timetable, a realistic timetable. And often a lawyer will set a timetable without any kind of consultation with an expert. In those situations, there's not a lot that you can do. My advice is to, I guess, not take on too much, to plan your practice. And look, as lawyers, we need to do the same. Sometimes there's nothing you can do. The timetables all just collide and you've just got to work your way through it. But my recommendation is to just try and manage what you've got, work with the lawyer if you can in terms of setting the timetable so that you can get a realistic time frame ahead and work to that.
Can the lawyer, if they're running late, blame us? Because I get literally only just something this week. Haven't heard from 2 years.
Yep.
And I'm always paranoid that we get thrown under the bus and not
We would never. We would never do that. Look, I can't speak for others, and unfortunately for you, often you don't know what's being said to the court. But generally speaking, so for me, I'm having to put on, as I said, an affidavit today because my expert got sick, and there's nothing that I could have done about that, or that he could have done, in fairness. I have to put on an affidavit, and it is setting out the correspondence. No one has been sitting on their hands. He had planned to do it over the long weekend. He got sick. This is what happened. For that particular expert, another law firm came in and said, I've got a guillotine order. I've got to go to the top of the list. He hadn't anticipated that. So look, they can. You don't know what they are doing. David and I would never, though. Anyone else?
Any further questions?
All right, I'll hand over.
All right, thank you, Sharon.
I think in fairness, in a bit of barter also, we've got, Bartier Perry have been presenting to us for a lot of years, and Sharon's came into the last, 5 or so. And this combination of dual presentations, I think, is really great. And it's getting to the point where we nearly need to have a bit of a vote on how to Bartier Perry present. Which one is the better presenter? So thank you, David.
Yeah, no, you're welcome, Graham.
I have to bow down to David because I can't pull off a joke the way he can.
Yeah.
I'll graciously
Yeah.
defer to David.
I think you should just go on, the legal part, not the entertainment part. To be fair, however, okay. So I'm talking to you today about the independence of experts, and you've heard me stand up here before and bang on about you're an officer of the court. Your first duty is to the court. Only your second duty is to the client. You have to give your opinion, not influenced by what the client wants and what the client's objects are, even though you're being paid by one side or the other. Well, that is correct, but, and like these things, there's always a but, and I'm going to talk to you today about a particular case which essentially said, yes, an expert has to be independent, but if an expert isn't independent insofar as the expert's association with a particular client, that's a matter that goes to the weight of what the expert says, whether you believe what he or she said or give it more credence than the other expert. It doesn't necessarily mean that their report is to be excluded, that it's not admissible. So it can go in, but it may be looked at, with a pinch of salt, as it were. So it's not a building case, but the principles still apply. So this is Save Wallam. It's an environmental thing. So what you had was you had an expert, an environmentalist, who was also part of the environmental group that was bringing the case to stop a development. So what I've got there on that slide is essentially what the summary of it. So independence goes to weight, not admissibility. The admissibility of the evidence isn't governed by court rules, practice notes, or the code of conduct. That's not the admissibility. Admissibility is determined by the law of evidence and the Evidence Act. So whilst the codes of conduct and the practice notes and the rules are a guide, and they're wagging their finger at you and saying you need to make sure that you are independent, this is what you should be doing and you shouldn't be biased, they don't go so far as to say your expert report won't be admitted into evidence. It's a question of what weight it's given. So what was this about? So this is Federal Court of Australia. As I said, it's an environmental thing. The judge initially rejected the report. So the developer said, this guy is biased. Clearly he can't say that he's got no connection, that he doesn't have preconceived opinions, so his report ought not to be admitted at all. And the judge said, yep, that's right, I'm going to exclude it. The plaintiff actually got another barrister, a new barrister, who said, no, that's not right. As a matter of law, as a matter of principle, you can't exclude a report because you think the expert might be biased. You have to let it in. It's what you do with it after that then matters. And the judge, in her judgment, said, yes, you're right, I didn't know about this line of case law. So, we all learn something every day, particularly about the law. So the key issue was, could this ecologist report be excluded because of lack of impartiality, or does it have to be let in? And it was originally excluded. I mean, you can see there, he'd written letters to the ministers and to the local council about it. He'd been in the media commenting about it. And as I said, he'd had direct involvement with the environmental group. And for that reason, the judge initially excluded his report. However, the judge then set her own ruling aside. Sounds a bit strange, but that's what she did. She said, I have misinterpreted the law, I've misapprehended the law. Independence isn't a third criterion under Section 79.1 of the Evidence Act, but Section 79.1 says that an expert, well, initially it says opinion evidence isn't admissible, but it is, the exceptions are, if it's in an area of a technical area where technical expertise is required and the person who is giving the report has that expertise. They're the only two qualifying factors. That's it. Otherwise, if you satisfy those two, it's got to go in. It's all these other peripheral pieces of legislation or subordinate legislation that the practice notes, the expert witness code of conduct, that talk about bias and impartiality and your duty being to the court and so on. And whilst that is true, it doesn't go to admissibility, it goes to weight. So his report, because it was an area that required expertise and he had the relevant expertise, was admissible despite his prior advocacy for the environmental group. Now, sorry, I'll just go back one. One of the primary authorities that says you've got to allow this evidence in, even if you don't give it weight, is Rush and Nationwide News. So Rush, that's Geoffrey Rush, the actor. You may recall he's one of the very, very few celebrity plaintiffs in a defamation case that's actually won his case. I think it's currently the biggest award of defamation damages in Australian legal history anyway. I think he got $2.8 million or something. That was an allegation that he sexually abused or sexually harassed an actress in one of I think it was a production of Hamlet. So he was successful in that. And the relevance was, or the relevance to this case, the principle was that he sought to adduce evidence from his agent and from another person in the entertainment business who books actors, who knew, and both of them knew him very well, obviously. And the relevance of the evidence was, he was saying, in terms of his damages, because of the slur on his reputation, he was going to lose work. And so the relevance of the evidence was, how much work was he likely to lose? And the defendant in that defamation case, Nationwide News, said, no, these reports shouldn't be allowed in because of the prior relationship that the experts have with Geoffrey Rush. And what the court said there was, well, no, it is an area where the court needs the assistance of experts. These people have the relevant expert knowledge, and therefore their reports are admissible. Now, whether the court then gives that a lot of weight, whether the court says, well, you would say that because you know him so well and he's your mate and you're going to get further work from him or not, that's a different story. But in terms of their evidence actually going in, it's allowed to go in. So that's the basis of that. And look, where it may come up in your sphere, so for example, we had a case earlier this year, I think, and it was an issue of the engineering design of a balcony. Graham was involved in this, and initially the homeowner brought the claim, said that the builder hasn't built it in accordance with the plans and specifications, and therefore it's structurally inadequate. The response from the builder, and she put on a report from the engineer who'd done the design. The builder's response to that was to say, well, although he denied that he departed from the plans and specifications, he said, and anyway, if I have, the original design wasn't structurally adequate anyway, so where's the loss? Now, when we came into it, we said, you need to get an independent engineer to give an opinion on whether or not the original design was structurally adequate, because of the impartiality, or rather the partiality, or the perceived partiality of the original engineer who designed it. Because you would think, of course, he's going to say there's no problem with it. It is structurally sound. Now, that was a forensic decision that we took, because what we didn't want was having the sole expert he wasn't a party to the case, but obviously he was very involved in the case. It was his design, going in and having whilst probably the other side would have said that his report's not admissible because of bias, etc., we could have relied on this principle to get it in, but then we've got to convince the member that he's not being partial, he's not being biased in his own favour and supporting his own design just because it's his own design. Now, obviously that's a pretty hard ask. So we got an independent engineer who confirmed that there was nothing wrong with the design, and ultimately we were successful in the case. We did put on evidence from that engineer, but it was evidence of fact, as in these were the plans that I designed, this is the departure from these plans. That's a matter of fact. It's not really a matter of expert evidence. Whereas the other expert engineer said, and we have modelled these plans, and the modelling shows that if the veranda had been built in accordance with the plans, it would have been structurally adequate. So that was that. You had a question? Was there a loss? Oh, absolutely. It had to be demolished because what the builder had built wasn't structurally adequate. So yes. So it failed. Yeah. Or would have failed. Well, when I say would have failed, the piers, the metal piers, were bending. You could see that. So ultimately, yes. I mean, it was caught a few months in.
One of the client's criteria in their design initially was they wanted a very minimalist look. They didn't want a big, bulky, huge veranda.
I think you're a bit close to it, Graham.
It's a bit partial. Yeah, it was a really dodgy job, let me say.
Form follows function.
Okay. So, any other questions? No. Okay.
Graham's like, move on.
Well, go on. Okay. Right. Sorry, I'm taking too long.
We won, Tom.
We did what? We did. We won. We got costs. The judgment's been paid. The costs will be paid on the 1st of July. So, all good. Everyone's happy, except the builder.
I got paid.
Yeah. And his report was on time. What was the point? Okay. All right. Thanks, gentlemen. Okay. Sorry. Neil, did you have a question, or you? No, just the joke. Okay. All right. Well, what can I say? So we had a little segue. Had our granddaughter over yesterday afternoon, picked her up from school, and when she comes over to our place, she likes to stop at McDonald's for afternoon tea on the way back, and that put me in mind of a story I heard about an elderly couple who went to McDonald's, and they sat down near some younger people. The elderly guy gets up, goes to the counter, and asks for one cheeseburger meal. Although he's there with his wife, he gets the cheeseburger meal and he goes back to the table, and he carefully cuts the cheeseburger in half. Then he counts out the fries, 50-50. He got 2 straws for the drink, puts the drink in between the two of them, and the wife starts to eat her half of the cheeseburger and pick at her half of the fries. And there's a younger couple sitting next to them or just across from them. The younger guy gets up and says, "Look, I've seen what you're doing. Let me pay for another meal so you don't have to share." And the lady looks up at him and says, "Look, thank you, that's very kind, but really we share everything." Okay, so he sits back down and is watching this couple, and the older lady is eating her half of the cheeseburger, eating her half of the fries. The guy is taking a sip of the drink every now and then, but he's not touching his half of the meal. And the young guy just can't stand this. He gets up again. He says, "Look, really, it's no problem. It'd make me feel good if I can buy another meal." And the older guy says, no, truly, we share everything." And the young guy says, "Well, then, your half's there. What are you waiting for?" And the older guy looks at him and says, "The teeth." Thank you all.